Good evening and welcome to the Wednesday, November 13th, 2019 Plan Commission and Commission for Citizen Involvement meeting. I'd like to now call the meeting to order. Iris, would you please call the roll?
Beckett? Here. Fisher?
Here.
Hanson?
Here.
Heap?
Here.
Papay?
Here.
Ward?
Here.
Thank you. We have quorum. First on the agenda is a council update. So we did receive an email from Councilor Windland that he would be unable to attend tonight due to some unavoidable scheduling conflicts. He did send us some email. I can summarize what he said. Number one on the list was that the council voted not to participate in the Oak Grove Lake Oswego Ped Bike Bridge project that was being considered by Metro and Clackamas County. For various reasons, council thought resources should be put in other infrastructure projects that are a higher priority for Lake Oswego. So that was one. Also, council withdrew support for the proposed communications tower at Cook's Butte based on notification of withdrawal of support from the family that donated the park's land with restrictions. The third update was council supported a demolition ordinance of $15,000 for the demolitions of a house for new construction. Any revenues collected would be used for park maintenance. And the third and final update, Laura approved a request for a proposal package from City of Lake Oswego for the North Anchor project to be used to obtain project proposals from developers. Proposals are due by February 2020. So those were the three updates from Councilor Windland. Next on the agenda is a citizen comment. This is regarding issues not on the agenda. There's an opportunity to raise issues regarding planning. A time limit of 3 minutes per individual applies. I do not have anybody who's submitted a request to speak on citizen comment, so I'd like to move on. Next on the agenda is minutes, the October 28th, 2019 minutes. These are not available, and we plan to review them on November 25th. And then next is Commission for Citizen Involvement. General updates. So we do have a number of updates tonight. First, the Evergreen Neighborhood Association is holding their holiday party and raffle. This will be held Friday, December 6, 2019 from 6:30 to 8:30 p.m. at Johnston Financial, 334 3rd Street between A and Evergreen. So anybody interested in attending the Evergreen Neighborhood Association event is encouraged to do so. We also have notice that there'll be a holiday caroling event. This is from 7 p.m. until 8 p.m. Friday, December 6th. It's featuring the sounds of the internationally celebrated vocal ensemble, the Portland Phoenix Choir. They'll be meeting at the Peg Tree, 141 Leonard Street in Lake Oswego. So I encourage the community to attend that Old Town neighborhood event. I think that was it for citizen involvement updates. Commissioners, any updates at the commission? No? Okay. Next, we'll move then into item number 7 on our agenda, public hearing. This is the Community Development Code Annual Amendments for 2019, LU 19-0033. Public testimony is accepted. 5 minutes per individual applies. We do have a lot of material to go over tonight, so those making comments, I would ask to try to stay on track and keep within the time limits for public testimony. This is a request from the City of Lake Oswego to amend the Community Development Code to clarify and update various provisions regarding non-conforming structures, accessory dwelling units, the Lake Grove Village Center and downtown redevelopment design, district overlays, certain building design standards for residential structures, clear and objective housing standards, parking for certain commercial uses, street connectivity standard for metro plan references, lighting applicability standard, various development procedures, ministerial and minor development classifications, expiration deadlines, most specifically for major public facilities, flag lot access lane standards, general and DRD-specific design variance criteria, applicability, and definitions. The staff coordinator is Johanna Hastay, senior planner. Senior Planner Hastay, would you like to
Well,
get us
let
in?
me just
Deputy Attorney
Yeah.
Boone, yeah, please
I'll set
preface.
the context and then
Sure, thank you.
yield over. This is a legislative decision, which is generally a policy decision within the discretion of the City Council. The Planning Commission will review the legislative proposal and make a recommendation to the City Council. Although a legislative decision may be discretionary, it must also comply with any applicable state law as well as any applicable statewide planning goal or administrative rule adopted pursuant to ORS Chapter 197. A legislative amendment to the Community Development Code must also comply with any applicable provision of the Lake Oswego Comprehensive Plan. The public hearing process will begin with a presentation by staff, then testimony will be received from the public. Individuals will be allowed up to 5 minutes. Recognized neighborhood associations, homeowner associations, government or government agencies, or other incorporated public interest organizations will be allowed up to 10 minutes. The time limits will not include time taken by questions from the commission or responses to those questions. Testimony by attorneys, representatives, and witnesses on behalf of or which are part of the presentation by a person shall be counted within that person's time limit. Any person in attendance may cede his or her time for testimony to another person, but in no case shall any person's testimony be increased to greater than 10 minutes. At this point, I would ask the commission members to please declare if you have any financial conflicts of interest. Commissioner Hanson. Mr. Beckett?
None?
Word has none.
None.
None. All right, thank you. Senior Planner Johanna Hastay with the staff report.
Thank you. Good evening, Commissioners. As
Evening.
noted, Johanna Hastay, Senior Planner with the Planning and Building Services. I am here tonight to talk briefly in this presentation about the 2019 annual code amendments. I do have some exhibits to add to the record. Exhibits G1 and G2 were specific to item number 14, which amended how lot coverage on future flag lots would be calculated, and I'll delve more into those exhibits, and I see a number of other people here with a Measure 56 notice, but I'll get into that a little bit later in the presentation. And then Exhibit G3 is a letter in support from the Chamber of Commerce regarding the valet and tandem parking. So just a brief update on the schedule. We are making progress. We're at the public hearing with the commission, and we'll come back for findings on November 25th, and then the City Council public hearing will be on December 17th. So one of the of the 23 proposed code amendments required that we send out a Measure 56 notice because it changed how development would be allowed on privately owned property. And item number 14 specifically, like I said, dealt with how on a flag lot, lot coverage would be calculated. Lot coverage is a ratio of lot size to building height. And flag lots specifically, you cannot count the area in an access easement or a flagpole that leads down from the flag lot to the private or to the public street. And I do apologize. I believe I could have done a little bit better with that Measure 56 notice. I did receive a number of phone calls, people wanting some clarity on it. A lot of the comments that I received when I spoke to property owners directly, they were worried about potential loss of density. This does not do that. And that was Exhibit G2, and I did speak directly to that property owner and clarified for him what the amendment was. But for everyone here in the public, basically what this proposal does is ensure that our code is consistent in that if you have a flag lot that has an access easement over it, meaning it's a middle flag lot, you have a front lot, a middle flag lot, and a back flag lot, and you take access from the public street to the middle lot through an access easement, that area in the access easement won't count towards the lot coverage determination. So again, flag lots, you calculate, you go to the boundary of the flag lot, and whatever that lot size was, say 10,000 square feet, the area in the access easement would come out of that, say 2,000 square feet. So you'd be left with 8,000 square feet with which you would calculate lot coverage, which is the percentage of lot area. So if you had, say, a 26-foot tall height, 26-foot tall house on a flag lot where the area that you calculate is 8,000 square feet, it would be 25% of that 8,000 square feet, which is a lot of numbers. So sorry about that. I know it's confusing. But basically, again, all of this amendment only makes sure that our code is consistent. We have been calculating lot coverage for flag lots this way for a number of years, and we've been trying to fix some inconsistencies in the code around this issue. This is the last inconsistency because the definition of lot coverage itself refers to gross acreage, which implies that you would include the area in an access easement or a flagpole, but in practice, we don't do that. So what this amendment does is clarify in the end that homes on future flag lots will be slightly smaller, typically anywhere from 100 to 200 square feet in size. But again, it's how building permits have been reviewed for years now, since we've had flag lots. So hopefully that clarifies, and I'm again happy to answer any questions for people and from the commission. I apologize again that the Measure 56 notice created some confusion. But other than that, and I'm happy if the commission has any questions, I can go over them. But in general, the proposed amendments do comply with the applicable comp plan goals and policies. And I don't want to spend too much time talking about them, since we do have a number of people here in the audience and we have a number of items to go over for deliberations. So the three amendments that I am going to focus on in my presentation are the three policy amendments that weren't fully resolved at the last work session, and that's item 18, setback plane projections for the front and side yards. Number 22, conditional use permit deadlines and expiration deadlines, specifically for major public facilities. And item 23, if there were any remaining questions on how the ordinance in the amendment was written for the valet tandem parking that will be allowed for certain commercial uses. So number 18, and if you're in the staff report, if you're using the staff report, please look at attachment 2, and that's pages 23 through 29. If the commission remembers, at the last work session, you were presented with a number of options, and you narrowed it down to what ended up being 3 options to move forward with trying to make the code around side yard setback planes and front yard setback plane projections a little bit clearer and easier to implement. So option number 1, this is the one that was recommended for approval by the Builders Advisory Group that we've convened. Basically, it is the most general approach to this standard. It would change all discussion from, or all words that are specific to dormers or gable ends to projections, which basically allows any sort of massing to appear or to project into the setback planes, regardless of how it's designed. That does mean that there will probably be an increase in the type of massing overall, but the dimensional requirements surrounding the setback plane projections remains the same. So the pros and cons, I think, are pretty clear. I think the number 1 con is that there's the potential for more massing beyond what was originally envisioned by this infill standard when it was first adopted in for the front setback plane in 2003, and then for the side yard setback plane in 2008. Option number 2 is a slightly less general approach. Right now, wall plane dormers are not allowed, and the commission, during your last discussion, did see some aesthetic benefits to allowing wall plane dormers. And so this would modify the language to allow dormers that were enclosed in a roof on 3 sides. And so the example that you see up here meets that standard. It's what we call a wall dormer. So the pros and cons there, again, pretty obvious. There is a potential for slightly more massing than what was originally envisioned under those standards as written. And then the third option basically maintains the current code, but adds a lot more clarity, again, to make it more clear and objective. It puts in very defined rules for dormers, that they have to be fully enclosed in a roof form and stepped back. So that example that you see there on the far right would be the type of dormer that would be allowed to project. It's just one type of dormer. But it definitely maintains the level of current massing. It might actually reduce it a little bit. It does, with the extra clarity comes the lack of flexibility with that language. So with that, I just wanted to turn it over at a certain point, either now or in questions at the end of the presentation. The next step would be for the commission to determine which of these 3 options you want to forward to the city council for their review. Do you want to talk about it now or at the end of the presentation? Do you have any questions for me?
Yeah, questions, commissioners. I guess I had one question was on option number 1. Could the projection go across, currently in option number 1, the example that's given, there's a recessed area over the door. So could the projection extend, just straight across Would that be allowable? And
Basically, whatever met the width requirements, so if you have one projection, it can be 1/3 of the width of the total facade.
Oh, okay, so there is some width restriction on it
Yes,
then.
there is. So for a single projection, it's 1/3 of the width. For two or more projections, it's 1/2 of the width. So whatever massing it was that was projecting into the plane could be whatever it was, as long as it met those width requirements, those percentage requirements.
Commissioners, any questions? Would you like to give feedback now then on the options the commission prefers? Commissioners?
So you'll have a, sorry, Chair,
Yes.
you'll have a public hearing and perhaps after testimony, if there are further questions or in your deliberation.
Right, so sorry,
Yeah,
any
that's a good
questions for
point.
me right now about these options?
Yeah,
And then
let's
we'll
go
get
ahead
to
and we'll
it
get the
during
public,
deliberation.
after the public testimony.
Okay, sounds good, thanks. Okay, so the second one that wasn't fully resolved is item number 22, which is the major public facilities expiration deadlines. So the commission was clear at the last work session, you want to streamline the two code sections that talks about expirations and deadlines into one. And then as far as how they pertain to major public facilities, you wanted to maintain that the conditional use permit never expired. So once approved, it was exempt from any sort of expiration deadline. And then for the DR portion of it, you explored the idea of between 4 and 5 years. You saw benefit to allowing it to be a slightly longer deadline than a typical DR permit, a non-public facilities DR permit. And so you asked staff to draft language that was somewhere between 4 and 5 years. So I did reach out to staff, including the department heads who manage these major public facility permits or projects. And they saw the benefit of a 5-year deadline, which adds some flexibility, but not too much that it gets a project beyond the public awareness of how and why it was approved. So that is how the ordinance was written, with a 5-year deadline. And then finally, the last one about the valet tandem commercial parking for certain commercial uses. Again, there were some questions around the final language there about attendance and other issues, and we can go over that in more detail during deliberations. But there is some minor language to work out there. We did get, like I said, a letter in support from the Chamber of Commerce. So then I do have 2 slides talking about the other maintenance and policy amendments. We can use that during deliberations to come back to. I'm not going to spend any time talking about them now. Yes, Commissioner Beckett?
I had notes here that you talk about parking in the FMU zone. What does FMU mean?
That's the Foothills Mixed-Use Zone, which actually doesn't exist at this point. The overlay was never adopted. The zone dimensional standards were, but the overlay wasn't adopted. It's down in the Foothills area. So when that overlay is adopted, tandem and commercial parking are already allowed there, and so we're tailgating on that for other commercial uses. So like I said, I do have the 2 slides where we talk about the rest of the maintenance and policy amendments, but I won't go over them in detail during this presentation. And with that, I am recommending, after deliberations, that the commission direct council to adopt ordinance 2832 as proposed or as finalized here tonight. Thank you.
And if I can just add, of course, what the commission has previously discussed in work session was direction to staff for purposes of putting together a public hearing version for public testimony. So the commission hasn't made any decisions at all about any final wording or anything like that. So the public is welcome to testify on any of the provisions.
Thank you. So I would like to open the public hearing at this time to receive public testimony. To have a list of individuals that have requested to provide a testimony. If anybody has not, I would point out that we have the kiosk up here. So if you'd like to put your name in, you'll be on the list. So first on our list is Cliff Warren. Cliff, would you like to come up, state your name and address for the record, and then give testimony?
My name is Cliff Warren, 4291 Sunset Drive, Lake Oswego. 97035. My question is, I don't really understand all of this. All I know, I've been here forever, and I have a lot, and it's either going to be devalued or maybe not. But I don't know why you have an opportunity or how you can change the law, because based on what I think my property's worth, and I came in and talked to the city, and they said they could build 3 houses on my lot. And it's 110 feet wide and 250 feet deep. And they said, yeah, you can build 3 houses there. So they'll tear my house down when I go and put 3 houses in, but I don't know whether that's going to still stand or it's been reduced. So how are we going to figure that out?
Thank you. One question. So on the code amendments that we have tonight, there's actually 23 items. Can you refer to the specific code amendment that is concerning you, or?
No, well, what concerned me was the letter that came out that said that it may decrease the flag lot road in from the overall piece of property. It would limit what you could put on there. So.
Okay, we'll ask staff to respond. I believe the concern is the flag lot, item number 11 on our amendments that revise the flag lot standards to allow up to 3 lots to be, no, not that one, right? It's the actual 14, sorry. The definition of lot area or lot size and lot coverage. Yeah, Senior Planner Hastay, would you
Sure.
like to comment?
And again, it's not an easy one to explain, so I apologize please continue to ask me questions. But item number 14, it does, in the end, it finalizes how we calculate the allowed footprint of a house on a flag lot. And it does decrease it by a small amount, like I said, typically anywhere between 100 and 200 square feet. But you still get the same development potential that you had before. It's just codifying our current practice of taking the access easement out of the calculation for lot coverage, which is, again, the footprint of the future house. So it's a small amount. There are some lot coverage bonuses that you can get with certain designs. And looking at it, in my experience reviewing building permits and talking to developers, it shouldn't have a major impact on the value of a piece of property and what can be built on it. And that's my professional opinion. So I'm not sure if that clarifies the question.
About the number of lots.
So the number of lots does not change. It's just the size of and again, it's only for a flag lot that is provided access from a public street through a pole, which is a dedicated extension of the lot down to the public street. Or if it's a middle lot, a middle flag lot, meaning there's a front lot, a middle lot, and a back lot. That middle lot has an access easement that the back flag lot would use to get access to the public street. That area in the access easement wouldn't count towards that lot coverage, so it's the small decrease in footprint.
Okay. But if it was decreased to a point where you had to put a smaller house, you're talking less money as far as the value of the overall project.
Potentially, but again, this amendment codifies how we've been implementing lot coverage for flag lots for years. So this is not going to be a change that will surprise developers. This amendment, and the reason it was a maintenance amendment, not a policy amendment, was that this is how we've been reviewing building permits and enforcing building permits on flag lots for years. So again, I understand the concern, so I'm not trying to minimize the concern, but it's a small reduction, and it shouldn't, in the end, overall, have a significant impact on value. It does mean a slightly smaller footprint, but not significantly.
Okay. Good. Okay, thank you.
Thank you. We do have a question or comment from Commissioner Ward. Commissioner Ward?
I think a very simple graphic could explain this pretty easily, and I'd be glad to draw it on that board if I had something to draw it with, and it wouldn't take long at all.
I would be fine with that, if there is something.
While we're waiting, Commissioner Hastay, is there something that we could actually, sorry, Senior Planner Hastay, is there something that could be added to help with this? Because this is actually some, in terms of the concerns that are stemming from density, we had Exhibit G2 which had a density concern, and then we have more input tonight on
Yeah.
density. So is there something that we could do that may help explain?
I
Because
mean, it's
I
a-
think the other problem with, trying to explain maybe loss of value based on some type of coverage change, perceived coverage change, even though it's been applied like this, I think that would be a little bit more difficult, but the density, I think, might be explainable.
I mean, this is only an amendment to the lot coverage definition, and it
True.
doesn't even touch how density is calculated in a totally different section of the code. So I understand that, it's completely lacking context, but what Commissioner Ward is showing there is, if you mind if I walk it through and then you can add on, Commissioner Ward? So the bottom lot there is the front lot, and the public street down below. The bottom lot is the front lot, and that is a non-flag lot. The middle lot, and actually, would you mind turning that, the access lane into a dashed line, so it's, okay. So the middle lot is a flag lot, meaning it doesn't have frontage on a public street. And so that area to the left, which is an access lane, is not included in how, it's already not included in how a flag lot has to meet the minimum lot size of the zone. So if the minimum lot size of the zone is 10,000 square feet, you only get to count the area that's shown to the right of that access lane, the flag portion.
Does not count.
It did,
for
so the
lot
access lane does not count currently. And so that's how
It's the
code is
whole
right now.
deal.
Yes, and then the back
Just
flag
the
lot,
map.
because it doesn't have an access easement, you get to count the whole thing towards the minimum lot size. So you go from the edges of the property line there. So to answer your question, Chair Heap, I'm not sure that I would definitely not recommend adding in a graphic to the lot coverage definition. The problem is that lot coverage said gross acreage, which would imply the entire flag lot, which, again, with a middle flag lot or a flag lot that has a pole extending down to the public street, that's not correct.
Thank you.
But
Commissioner Pape, question?
When you say, been in practice for years, you quantify that? I think that might helps folks understand 2 years, 20 years, how long has?
that's a great question. And the flag lot ordinance was, I believe, adopted in 1989. Or is it 92?
98?
98, sorry, 89, 98, I'm getting my numbers mixed up. There was a major amendment to the flag lot standards in 2011 that came with a lot of new code. And at some point along the line, somewhere in there with all of the code amendments that happened, there was a confusion. There was different code of how you measure floor area, how you measure lot size, how you measure lot coverage. Some of them talked about gross acreage, some of them talked about net developable acreage. Someone said, it was very confusing. And so we've been trying over the years to catch all these different ways so it's consistent. For a flag lot that has an access easement or a pole, it's a little bit smaller area that you count towards all of these measurements. The minimum lot size, potential floor area, which is massing, and lot coverage, which is footprint.
So, in essence, what we're talking about was. Thank you. What we're talking about here was passed in 1989. Correct.
Before 1998, we didn't have a flag lot ordinance. And so we had lots that looked like flag lots. We didn't have a formal flag lot ordinance. And then, so yes, it was adopted in 1998, and then it went through a major revision in 2011.
Okay.
And we've been kind of.
And so if someone were doing any type of flag lot construction or wanting to develop their land 3 weeks ago as opposed to 3 weeks from now, there wouldn't be a difference
No.
in what is calculated and how that
That
is
is
handled.
correct. So the code, if you look online now, if somebody were to look at the code and say, oh, I've got a flag lot, I wonder how big my house could be. There's actually built into this lot coverage definition, there's a cross-reference back to the flag lot standards, which says specifically, flag lots do not include area and poles or access easements. And that was a kind of in the meantime fix that we had because people, I don't think it happened that a lot of people were confused, but staff noticed that there was an inconsistency in our code. And so this code amendment was like hopefully the final fix. So Again, for those three metrics, lot size, floor area, and lot coverage, it only uses the area in the flag portion of a flag lot.
And I might add, the reason that we send out the notice that brings this to the public's attention is that anytime there's a code change that may even raise the question of, just as the question's being raised this evening, is does this affect the usable area of my lot? Or does this affect the number of lots that I can receive approval for? We err on the side of notifying the public that we're proposing to make this change so that these questions can be addressed in an open and transparent manner. So that's why you've all received the notice, and I believe Senior Planner Hastay's explained why this is before the Planning Commission.
And so just to follow up on that, again, most of the people I talked to, everyone that received the notice has a residentially zoned lot that is at least double the minimum lot size. And I erred and I said every single residential zone. And I had our GIS department, our Geographic Information Systems department, call out every single property owner that owned residentially zoned property that was at least double the minimum lot size. So it could be divided through a minor partition or even further by a subdivision. And I didn't look at where existing homes were. I didn't look at sensitive lands. I didn't look at anything that might actually impact how a land could be divided. And I sent out this notice. And then again, a lot of the phone calls I got back, most of the people, their question was, how many lots am I going to be able to get? And the answer is the same as you had before. And a lot of times what would be necessary in order to even deal with this issue about what size house you could have on a flag lot wouldn't even come up without tearing down your existing home. So it's not an immediate impact. It's like yours, sir, that you would have to either sell your property as a developer would come in, but it means tearing down your existing dwelling and then going through the partition process and then getting a building permit for that home.
Yeah, then how would I determine what size that driveway has to be?
There are a number of sort of variables that we could look at, but if you want to, I can give you my contact information and we can look at that further for your specific property.
Okay, great. Okay, thank you very much.
Thank you. Commissioner Fisher, a question?
Yeah, there's an ordinance that says that you have to reserve that flag portion, and it can't be counted in the flag lot acreage or square footage. And so we're not changing anything, we're just clarifying things.
Okay.
I hope,
Yeah.
does that
Yeah.
ease? Okay.
But again, for anyone in the audience, I'm happy, if you want to contact me directly, I can talk to you about your specific property, if that was your question.
And we do appreciate residents showing up and out of curiosity and asking these questions. So it's important that you're paying attention, and we appreciate it.
Yeah, absolutely.
Thank you, appreciate it.
You're very welcome.
Can we have your information?
Yes, I'm sorry, I don't have any cards with me, but if we take a break, I can run up and bring some down, or maybe someone, I'll just give you, tell you right now. So it's my email is my first initial last name. So J for Johanna, H is in Harry, A is in Apple, S is in Sam, T is in Tom, A is in Apple, Y is in yes. So J Hastay at lakeoswego.city. And my phone number, if you just want to call, is 503-534-5740. And all of that contact information should either be on the agenda item tonight or on the Measure 56 notice that you received.
Give me that phone number again, please.
503-534-5740.
Thank you.
You're welcome.
I do have one other person, Sandra Jackson.
I'm she.
Oh, okay.
Yeah, I don't have a flag light, I have a shared driveway. But I
If you'd like to come up and state your name and address for the record, and be happy to take your testimony.
Thank you, Iris.
Sandra Jacks, 2591 Green Tree Road, 97034. These two lots have gone through some changes. I've been in this house for 46 years. So originally, there were going to be 5 lots on one driveway. in the early 60s. And of course, the fire department said that would never work. So now there are just 2 houses, but the house that I share the driveway with had an address on another street. So I think it's been very confused. And I would just like to make sure it's clarified so that when I get ready to sell this house, we'll know what we've got. So that's why I'm here, and I got the message.
Right, well, it sounds like your questions have been answered, but you still have concerns, just making sure that it's a clear process.
We
that's
don't call it
easy
a
to understand.
flag lot, we call it a shared driveway. So,
Senior Planner Hastay.
Yes, again, I'd be happy to answer
Okay,
specific
thanks.
questions. Just
Thanks.
contact me.
okay.
Right, thank you. Next, I'd like to call James Bullen. Please state your name and address, and if you represent any association or organization.
Okay. Thank you, Chair Heap and Planning Commissioners. My name is Jim Bolland. I'm the co-chair of the Lake Oswego Neighborhood Action Coalition, LONAC, and I'm here tonight representing that organization. In our November meeting, our membership voted to make basically 4 recommendations to you on the items. Before I do that, though, I want to share a concern that came up in our discussion. And the concern was about making dimensional standard changes at this point in time without really knowing where we're going with the implementation of Oregon House Bill 2001. We know the Home Builders Association is already making recommendations about increasing dimensional standards. And so we're sure we're going to hear from them as that moves forward. So there's concern about starting to tweak dimensional standards now before we get to HB 2001. So something to think about. I'm going to comment on items 18, 19, 22, and 23. The first one is item 18 and the projections into the setback planes, and specifically on the dormers. And our recommendation to you is to go with option 3, which represents the current development code. We agree the graphics can be improved and should be, but the concern is why make an increase to the massing of the projection, the dormer projections? I know the builders group supported that, but I don't believe there's been any data really presented why that would be better to have more massing, why it's not working. Haven't heard any data to support that. So it seems we ought to stick with the current code rather than allowing more massing with the projections. Item 19 is removing the side yard setback plane for the steeply sloped lots. That ordinance came out of Infill Task Force 2, of which I was a member. And I would say again, I actually I joined the meeting where the builders group was talking with staff, and they recommended removing that. Again, there was no data presented as to why we should do that, other than it would allow for bigger structures. I mean, the side yard setback plane that applies to all of residential housing in other parts of town, in flat lots, slightly sloped lots, is there for a number of reasons. It reduces the massing of large houses. It's why we did it on the infill task force specifically to steeply sloped lots is because there are big problems on steeply sloped lots with the massing, the height and the feeling of those buildings. It seems like it would be a big mistake to remove that on steeply sloped lots. When we did that piece of code as part of the infill task force, We actually didn't have time before the task force adjourned. We didn't have time to really fully address everything that needed work on steeply sloped lots. And I would argue that it really hasn't ever been fully addressed going forward. Bill, you were part of that, I think. I'm sorry, but I think you remember what I'm talking about. We needed to address steeply sloped lots at all aspects, all facets, which way they go, So to to single this one out doesn't make any sense to us. Why we have the side yard setback plane is to, again, reduce massing, but it also has to do, especially on steeply sloped lots, with solar. It has to do with privacy issues. And I just don't think in the change that's recommended here, any of that's been addressed or analyzed. So I think we need to do that before we make that change. Thank you. 22, on the, talking about the timelines or expiration of the development review approvals and the conditional use approvals. We certainly agree that the DRC approvals are fine, whether it's 3 years or 5 years. I mean, whatever's reasonable. I would throw out to you, though, that, conditional use, to have those be, go into perpetuity, again, seems illogical because conditions sometimes do change. I mean, I know, I can remember several instances over my involvement with land use in the city where we've gone back and had to relook at a conditional use permit because conditions changed. So it seems like it would make sense. Once one of those things gets approved, there should be a time limit on how long you can go before you would I mean, if you're going to say, 5 years, more than that, it seems to me that something needs to be reviewed to make sure that nothing's changed. So recommendation would be add, again, 3 years, 5 years, whatever is reasonable, add a expiration date to the conditional use approvals too. And then the last one, item 23, the tandem parking is I think, complicated. And I live in the first edition, abutting the downtown, and I would say that we don't have a problem allowing tandem parking. I mean, that's fine. It's another tool. It's another arrow in the quiver. But our concern is using it to meet the parking standard. That's a big change. And again, we're concerned that not enough analysis has been done, that we're not going to, by allowing that to be used to meet the parking standard. Think about the parking standard. There's a lot of ways to meet it. There's a lot of ways to reduce in the downtown. There's many ways to reduce that number. Close to public transportation, reduce the number. There's a whole list. So now we're adding basically another one to further reduce the number. And the concern is with this one is that without analysis, we believe that it could end up forcing more of the downtown traffic into the abutting neighborhoods. So I think there's a real concern there before we, again, allow it. No problem allowing it, but the worry is it shouldn't be allowed to meet the standard. So that's what I have for you, and I'd be happy to answer any questions if you have them. Thank you.
Thank you. Commissioners, questions? Commissioner Ward?
Regarding tandem parking, I think it's very worth considering with certain limitations. That is that it not be necessary to use any part of the public roadway as part of the tandem parking situation. And although I agree that, perhaps not as much area would have to be devoted to new parking lots and new developments, it still seems to me that it's an economical way of achieving a greater number of parking stalls on a given site. And for that reason, I believe I'm in support of it. And if there are some other reasons that you and LONAC have come up with that we are not considering, we'd be glad to listen to those concerns.
Right. Well, I would, I'll give it my personal concern.
Sure.
You know, several years ago, we had a parking task force that was made up of all the downtown neighborhoods and the business community. And that task force was, I thought, pretty successful and had a whole list of recommendations. It's going back a while. I'm going to say it was back probably 2012, in that timeframe, 2013. Is that right, Scott?
I thought it might have been later than that.
I think Tom Coffey was the acting city manager when that task force was working. But their recommendations, they had a whole slew of recommendations, and they were never addressed. They were never brought forward to the Planning Commission. And Bill, I think you would probably remember that one too.
I think I do.
Yeah,
It's
and
quite
so.
a lengthy analysis, pointed out that there wasn't very much enforcement, for instance, and that was regarded as a problem, and there was
Right.
issues regarding the amount of time allowed in the various different areas, and that seemed to need to be reanalyzed
So that was
made it a little
that was an
more
attempt at master planning the downtown parking.
Yeah.
And again, so what I'm saying is, it's incremental. I think tandem parking personally is a good idea. I agree, it is. The concern, though, is if it counts against that parking, if it counts to meet the parking standard, then that's a bigger change than just having tandem parking, having it be legal to do it. I mean, it's only certain people are going to use it. I mean, it'll be pretty limited.
It's only
I think.
applicable to certain sites that can set their
Exactly, I mean,
parking
because it involves.
plan
yeah,
such that it
involves-
works.
Right, I mean, it involves other things too. But I worry about incrementally doing it without doing the master planning that the business community, with the support of the neighborhoods, was trying to do 7 years ago. So that's one of the reasons why.
Thank you.
Okay.
Thank you. No other questions.
Thanks.
Next, I'd like to call Robin Best. Sure, if you'd like to not speak, that's okay. Is that the?
I prefer not to.
Okay,
But my questions have been answered. Thank you very much.
okay. I do not have any other names who would like to speak tonight. If there's anybody that would like to speak, please come forward. So seeing none, I would like to close the public testimony at this time and go into discussion and deliberation with the commission. Commissioners, any further questions for staff? Vice Chair, Commissioner Ward.
I have a question for staff regarding valet tandem parking.
Okay.
Are we wading into a morass that we don't want to get involved with on this one?
No, we believe that we're not wading into a morass, that we're moving.
That might have been a little too colorful.
We believe that we're moving our code forward, albeit incrementally, as was mentioned, and looking at more efficient way of laying out a site and meeting a parking demand. We know that the industry is changing, and with more rideshare companies and services, that there is greater opportunity for this type of parking. And hotels, motels, restaurants, and other similar hospitality businesses have been doing this for years. And so, what we're proposing, I think, is in line with the market and contemporary planning practices. We are taking an incremental step. There are other ways that we could make our parking code more efficient. We have looked at other jurisdictions to see if our parking standards are competitive with neighboring communities and other communities in other states that are of a similar caliber and, attract a similar quality of development. We believe that we are competitive in the respects that we've addressed in the staff report with regard to hotels. We could probably be more efficient on restaurants and retail, quite frankly. I think if we were bringing forward a more comprehensive package of code changes, we would look at the parking ratios for some of those other uses, although, as was mentioned in Mr. Boland's testimony, there are other ways that the parking requirement can be customized for a particular development. There's a parking study alternative that an applicant can submit or propose that calculates the parking load specific to the mix of uses in their project, and that is applied for from time to time. What we're looking to do is to streamline the code and to remove as many obstacles as we can to getting to the most efficient layout that'll function safely and properly for all of the uses on the site and in the vicinity. So I think we're not wading into any morass. I think we're moving forward in a constructive way.
And I would again point out, just as it's written in the code, that this is limited to very specific uses. I would sort of see it as a test case scenario to, again, try to implement current planning practices to reflect where the market is going, but it's very limited in its use, so.
Well, I've seen in downtown Portland on private parking lots where there's an attendant present, and they pack those lots to the edge of the sidewalk. And it does look fairly efficient to me and workable, as long as there's an attendant available to move the cars as required. And I would also say, in my opinion, that none of this car jostling should involve any part of the public right-of-way. All of it should be occurring on the private site, which is the benefactor of the parking, the tandem parking situation.
There's a couple of things that I would add in terms of the design quality of our surface parking lots, to the extent that you can have a quality design in a parking lot. All of the site design standards that currently apply, whether it's landscaping or having pathways that allow you to traverse a parking lot, all of those requirements continue to apply. So it's really just about how the parking is managed on the site and making more efficient use of the ground that's there. I did want to respond to, if it's all right with the chair and the commission, the comments on the city's previous endeavors to study downtown parking and work that the downtown businesses and with the chamber have done since then to look at the parking situation. So the previous work, beginning in 2010, there was a parking analysis prepared by a consultant, a nationally renowned consultant, who looked at our downtown and found that there was adequate supply of parking, and it was really a matter of how the parking was managed. The pricing or time limitations for on-street parking was an area that the consultant had identified as something to look into further. Also looking at the parking ratios or the quantity of parking that we require for each development was something that they had suggested that could be more efficient. There were a number of other parking management strategies that they had explored at that time, in which the chamber and the downtown businesses have looked at periodically over time. And most recently, among the list of best practices that the chamber had identified through their parking subcommittee or task force was tandem parking. And so that's why I believe you've received testimony from the chamber in support of this proposal. So it is an ongoing process, and it's not a silver bullet, but it's a process of continual improvement with our code. That's all I have to say on it.
Thank you. One other question. You mentioned earlier that the FMU zone, the foothills mixed use zone, is, I guess, not applicable anymore, but yet we're adding this into the section of the code. Could you comment on that?
Okay, so I'm not quite sure when, but I think almost a decade ago, there was an effort to adopt an overlay zone down in the foothills area, the foothills mixed use zone. We did adopt the dimensional standards and that are associated with it. So you'll see it in the parking standards, you'll see it in dimensional standards, use standards, things like that. But The overlay itself was never adopted. The master plan never went forward. So it's kind of a ghost code in there, if you will. It's kind of a placeholder for if and when
Well,
that
yeah.
overlay.
It is a placeholder. I'm just going to jump in
Yeah.
again. So there is an overlay called the Foothills Mixed Use Zone that exists, and it's adopted.
Okay,
And
sorry.
for it to be applied to the it's currently the industrial and public facilities and open space zoning that's in the Foothills District. For that industrial zoning to be replaced with the Foothills Mixed Use Zone, there's an infrastructure plan that has to be carried out. And back in 2012, there was an urban renewal district that had been adopted to fund the infrastructure in conjunction with what was then proposed as a streetcar. And so all of that planning is in place. It does exist, albeit the standards are not affected because the infrastructure improvements have not, there's no funding mechanism. The property owners have not come forward at this point asking to apply the planned zoning for that area. So we looked to the Foothills Mixed Use Zone and the parking requirements there when we were considering this tandem parking proposal because we, as Johanna observed, there is already authorization for tandem parking in that Foothills Mixed Use Zone. So Ms. Hastay's right that the zone isn't currently applicable, but it does exist, and it once adopted with an infrastructure plan for the district, it would go into effect.
Correct, and so that's why we came up with a totally new subsection for the specific commercial uses, instead of how we originally wrote it in the draft code that you saw before, which was integrating it into that subsection B, which talks specifically about the FMU zone. So it's just, the one before you tonight is a standalone for these specific commercial uses.
One other question. I was curious, is stacked or lift parking called out in the same section? Seems that it would be relevant to the same type of concept as tandem parking to make it very efficient. Is that something that's missing from our code, or is it currently there? And I know the Windward public garage actually, or the private garage of the Windward makes use of it.
So again, there's a difference between how you calculate required parking on a site when it's being designed, when a development is being designed, and then how parking is then used on a site. And so, yeah, the Windward does have stacked parking. There are specific restaurants, I'm thinking of the Oswego Grill that uses valet parking already. And that's fine, that's actually allowed by code currently. You can implement tandem or valet parking as long as it doesn't interfere with safe ingress and egress for emergency vehicles or create safety hazards or anything like that. The difference is for these specific uses, you will be able to design a new site to actually be striped as tandem parking. You will be able to count that parking towards your minimum parking requirement. And then the valet parking, again, you'll still have to have a parking lot that meets minimum dimensional standards, as drive aisle standards, safe ingress and egress, design, landscaping, all of that. But it allows some flexibility in the future about how, say for a restaurant, valet parking could be used. So there's a difference between whether or not structured or like stacked parking can be used. Yes, it can. The building permits associated with it. And whether or not it can count towards the minimum parking requirement, and that's what we're talking about tonight.
Okay, thank you. Commissioners, any other questions? Would we like to then step through the amendments one by one and take any feedback?
Great. So I think probably the most useful would be to use attachment 2.
Yes, that's what I
That's what
do.
I'm going to be using, but again, I'm happy to answer any questions beyond that as well.
So item number 1, this clarifies the process for replacing certain damaged, non-conforming, non-residential structures. The main change, I believe, was the time limitation was removed. Commissioners, comments? Any objections? Commissioners in favor? Number 2. Item number 2, revise accessory dwelling unit standards for compliance with the House Bill 2001. Commissioner Ward?
Do we have a thorough enough understanding of how 2001 will affect us to be working on this at this time? Is my question.
Commissioner Ward, as applicable to accessory dwelling units, yes, we do have a clear understanding, and the statute is clear on what's required of us, and it preempts these two provisions of accessory dwelling unit standards, parking and residence.
Okay, thank you.
And that much, I won't go beyond ADUs at this point with House Bill 2001, because there are many questions out there.
Well, I know we have a lot of work coming up with regard to 2001, Measure 2001, and I'm not looking forward to it.
Commissioner Fisher?
Yeah, that, similar to this, you have the no more than one additional unit is allowed. Is that's in conformity with 201, 001?
I'll defer to Mr. Boone.
Yeah, so Commissioner Fisher, the House bill does distinguish between accessory dwelling units, duplexes, and other types of what they describe as middle housing. And for accessory dwelling units, by definition, it's one secondary dwelling or accessory dwelling associated with a single-family dwelling and detached single-family dwelling. So, and not more than one on a lot. When we get into the other types of middle housing under the House bill, then there's a lot to discuss about how many units where, and
Thank you.
that would be in addition to one.
Commissioner Beckett?
Yes, what is the nature of the revision to the ADU standards that you're contemplating at this stage?
So if you look on page 2 of attachment 2, we are striking the requirement that one parking space for the ADU be provided on site. That would be in addition to the required parking space for the primary structure. That's stricken by HB 2001. And then the next one is the requirement that the property owner live in one of the two residences. HB 2001 specifically strikes the requirement that the property owner live in one of the two dwelling units.
Okay, I would argue against striking about the parking standards on that. I think there's a lot to be considered before we take the requirement for parking off of the agenda. Let's wait till we get further into considering HB 2001. I'm thinking, for instance, of safety. Many streets in town are too narrow to wind up accidentally forcing traffic or cars to be parked on the streets where there isn't room for parking on the streets. So until we come to grips with things like that as we adapt to HB 2001, we should leave that parking requirement in the code.
So I'll defer to Mr. Boone on the legal ramifications of doing
Yeah.
that.
HB 2001 did many things, okay? Some of which became effective upon adoption, and some of which have a 2 to 3 year implementation process. And as Director Siegel indicated, the middle housing part, that duplexes and that sort of thing, that has a longer implementation process. The provisions regarding accessory dwelling units became effective immediately upon adoption. And those did two things: prohibited on-street, additional parking for on-street parking, okay, for that, and owner occupancy. Relative to your comment about safety issues about parking, we can, of course, prohibit parking on streets where there is unsafe conditions. That would apply to anybody who wants to park on the street. I mean, that's an unsafe condition, whether there's an ADU there or not. So that 2001 does not take away our authority, and we certainly continue that, to provide for safe parking on streets. And if it's not safe, we remove the parking, okay? I don't know whether there are any such situations, but my point is whether there's one house or two houses on that lot, okay, if you will, if there's a current right to park on the street, it doesn't make any, we're not identifying who owns the car that's parking on the street. We can prohibit parking on the street if it's unsafe. So I hope that answers your question.
It doesn't, because I think if we remove that, if we remove the requirement for parking, it will immediately force parking onto streets where it might not be safe if people do that development work.
Well, all I can say is, people have the option of parking on the street now, whether they park there or not, I mean, park on the lot or not. If there's an unsafe condition on the street, that should be identified to the city engineer so it can be posted for no parking on the street. That would apply to any resident, anybody that wouldn't park in that area.
Yeah, I would argue then that if we make this change, we need to simultaneously think through how we're going to enforce the safety standards of these narrow streets.
The statute has already preempted our authority to require the additional parking. So it's not a question of deferring the issue, it's a question of responding to the issue.
Thank you. I'd just like to add a couple comments to that, too. I see it very similar to staff. I mean, this was actually enacted, this section with these requirements to the ADU was actually enacted on August 8, 2019. So some of the earlier comments about, like we were talking about middle housing, I understand we're going to be working on that, but these specific provisions with respect to ADUs, unfortunately, I don't agree with the state on it myself, but unfortunately, I see this, these code amendment updates to bring us into compliance with what House Bill 2001 is. I did read through House Bill 2001 a little bit too, and I had a little bit of issue with, their terminology of additional parking. And so I read staff's report, and I'd say I would agree with that too, that if you look at the legislative intent and the legislative history behind HB 2001, there's a lot of concerns that communities were raising with various parking concerns like what we're raising tonight. But what happened is, it was clarified that, that their intent is to not require additional parking, not require a ADU parking space for that. So I think the recommendation here is well warranted to try to bring us in compliance with what HB 2001 is.
So just a little side note here, and again, this is the required parking. Anyone could provide additional parking on their site if they so wished, if the market drove them that way, excuse the pun, or if they had sufficient, they had a driveway, they could park a vehicle there. If they had more than a one-car garage, they could park the vehicle there. It's just a matter of, can the city with a building permit require that they create and dedicate a space, a specific space to or for the ADU? And no, we cannot. But again, I think there are a number of scenarios where you have no on-street parking, where if someone's going to build an ADU or convert part of their house to an ADU, that's one of the things that they'll probably logically look at and try to figure out a way to provide some sort of area for someone to bring a car. I don't think we're in a carless society yet, so I think that'll still be a consideration. I don't expect to see no parking associated with ADUs. I just don't think that's logical or feasible in a lot of scenarios.
Commissioner Beckett.
I have also read 2001 very carefully, and one of the caveats in there is safety. The word safety appears in there. So we may not be normally allowed to require off-street parking, but I think when it's unsafe to not require it, we would be off the hook in those instances to require off-street parking provision. Whether the resident there uses that or not, that's up to them, but I think in the conditions that I'm thinking of, on certain streets that I'm thinking of, most people would be reluctant to park out on the street.
Thank you, Commissioner Beckett. So just showing of the commissioners on this specific item number 2, commissioners, would you be in favor of the amendments as currently stated, or? Yeah, there's not much choice. All right.
Favorably agree with it. I mean,
Okay. Item number 3, amend the special street setback standards for the purpose of measuring required yards. Comments, Commission? Agreement? No issues? All right. Item number 4, revise the Lake Grove Village Center overlay to refer to the Boone's Ferry project for sidewalk lighting and remove an incorrect reference to dark sky lighting standards. I personally, I had a little bit of concern about this. I mean, the dark skylight lighting standards, I know it was mentioned that this went back to council maybe from, I think, 2005 to 7 or something like that. But it's it's almost like we're making a policy change a little bit to me. But I think the argument was that there was never really a policy put in place for this. I think it is unfortunate. The light pollution in the city is something to be concerned about, and it'd be ideally to keep our lighting kind of at a premium. But given kind of the history of this, I would be in favor of approving of this too.
So just really careful, quickly,
Yeah.
the lighting standards do, I don't know if you've ever read through them, but they are very specific and very rigorous. They're pretty painful, but they do, there's no direct reference to dark sky lighting, but the shielding, the no spillover, the maximum average illumination ratios, meaning like how much light is on the site, making sure that it's even and there's no glare. I mean, they're very stringent standards, so I don't think that this one gets
Really
us
change.
to like bad lighting. I think our lighting
Okay.
standards get us there. Our current lighting standards are sufficient.
So my concern was maybe that, again, we allow lighting to project upwards. There wouldn't be any shielding or covering over it into the sky. But you're saying you think that our current lighting code is pretty rigorous. And
Yeah, I can't speak directly to uplights. I know in the PF zone, the public function zones, the performance standard does reference uplighting, but again, it's minimized, and I'm not sure about the rest of the lighting standard. I think that there is, I can't remember a standard that would, I don't think there's I know there's no specific reference to dark sky lighting or not allowing uplighting, but again, the type of lighting that is allowed is very regulated, so.
one other question, when this really seems to be then just incorrect references and terminology,
Yes.
more so than it is changing our standards
That's
of
correct.
lighting. Has there been any input from like builders associations or developers that, it's a concern with cost and that, the standards are too rigorous and expensive? It sounds like that wasn't the
The
case.
current lighting standards?
Yes.
Well, I don't know that anyone really loves going through the analysis to make sure that they comply, but there are lighting engineers that are helpful for that. And I think everyone understands the value of having good lighting on an open-air parking lots or building lights, entrances, things like that. So I haven't heard any complaints about actually having to comply with the code. It's just the kind of,
Terminology.
going through the analysis can be a little
But
rough.
this is, I'm sorry.
But this
this
does
is-
not impact our lighting standards.
This is a reference to a code section.
That doesn't
Whether
exist.
you have that reference or you don't have that reference, they have to comply with applicable code sections.
Sure.
So this is a reference to a code section by dark sky standards, but we don't have a code that says that, but we have a lighting standard. They're gonna have to comply with the lighting standard. If there are any concerns about the lighting standard from a policy perspective, that should be addressed under the lighting standard, and there's no amendments to that point.
Actually, there are, but
Okay.
we'll get to this.
Okay, thank you.
It's actually number 7.
Okay. So I would say that the commission approve any dissenting opinion? No? Number 5, revise the LGBC overlay to allow removal of invasive trees if within the park street front environment. Any comments? None? Number 6, update the street connectivity standards to include the current Metro code reference. Seemed very straightforward to me.
Yeah.
Number 7, update and revise the lighting standard applicability section to be more readable and to ensure any change to open-air parking lot lighting is subject to review and compliance. Comments, concerns? None? Number 8, clarify which jurisdiction outside the city of Lake Oswego has received public notice. Comments or concerns? None? Number 9, clarify that recognized neighborhood associations may, under certain circumstances, receive an appeal fee waiver for appeals of the public hearing body decisions. Comments?
Yes.
I did have a couple comments on that. And it maybe relates to some of the other testimony that we heard tonight. With specifically thinking about House Bill 2001 and trying to understand the legislative intent, there was some specific examples that were given in this. And I was just wondering if so those examples will not be part of the code? I think that was just in the comment. Let me go back to item number 9.
So,
Yeah, I'll be more specific here. So,
and this is a procedural code section, so it's not specific to any particular project or any code. It just clarifies that, and it codifies our current practice of allowing a neighborhood association to apply for or request an appeal fee waiver of a public hearing body decision to the city council, not just a staff decision to a public hearing body.
yeah, so if I look at the staff comments and on page 12 of 37 on attachment 2, in staff comments on item number 9, it talks about that an example, i.e. a board or delegated committee agreed to file the appeal. My concern was if looking at legislative intent in the future, would that be the only limiting factor to say that, that the waiver in this specific code amendment could only be applied based on if the board or delegated committee agreed to file the appeal? I think it would be broader than that. Like some of my concerns and some of what we've been hearing as we've been discussing citizen involvement has been things like, what happens if the majority and the minority reports are not taken by the neighborhood association? And I think there was some interesting discussion on that. I mean, we said that, you wouldn't throw out the testimony. That wouldn't be part of it. One solution could be maybe in the future, the neighborhood could get its recognition removed. But this seems to be another aspect of it too, that if they weren't following the bylaws, then the waiver wouldn't be available. And again, my only concern was that in the examples, we might be creating some legislative history and an intent here to say that, we're only looking at one specific example, which was, did the board really, vote and make a decision, or the designee of the board to make this? So it would be, I think, more broadly applied to say, did the neighborhood association follow the bylaws?
So, what I did with this amendment was I just built in a cross-reference back to the original sections. And again, this is how it's been in practice, been implemented. I just noticed when I was going through a project that actually wasn't specifically stated in the code. So I think a discussion about how and when a neighborhood could file an appeal fee waiver goes beyond this maintenance amendment. This was just to clarify and to ensure our code was consistent with our current practice. So
Okay.
I think that your concern could still be dealt with as a part of the separate process with the citizen involvement committee guidelines or the citizen involvement guidelines. But for right now, I think this as a maintenance amendment, I just wanted to build in a cross-reference back to the existing code for staff appeal of a staff decision to a hearing body.
I'm good with it. Right. Number 10, revise the minor development school facility classification to ensure it only applies to improvements that do not increase traffic or impact the neighborhood. Commissioners? Comments or concerns? That's good. Number 11, revise the flag lot standards to allow up to 3 lots total to be served by an access lane, up to 2 of which may be flag lots. Commissioners' concerns? I did have another comment on this, and I think it goes along with some of the public testimony that we heard. I read this update and amendment many times, and I do believe it's correct. So, if I read it, it's very much matches, what I think we want the code to be and how it's applied. So, but I thought it was just confusing for the average person to read it. And the one thing that I thought was confusing was that we were combining driveways and access lanes. So I thought if some people may read it quickly or not have a full context to it, they may think that, the driveway and the access lanes are actually additive. that, you know, you can
Yeah.
add lots together. So one recommendation would be, instead of putting driveways and the access lanes together in number 3, that would be divided out. You'd have a section that was applicable to driveways and another section that would be applicable to access lanes, rather than combining them. And I think if they were broken out, it would maybe take away any confusion that, you know, driveways and access lanes are cumulative, additive. Does that make sense? or-
It does. I'm not sure that I've ever run into that confusion, like actually going through a minor partition process. But it's definitely, I would not want to just say that it would be as easy as creating subsection number 4. I'm not sure what sort of cross-references there are to this specific subsection number 3, so we'd have to go through the code and figure out if there is any specific cross-reference to.
Yeah, that's another thing that I
Yeah,
thought,
so-
so it may make kind of maintenance a little bit unwieldy.
If I may,
Sure.
maybe if the commission would like, we can do a little due diligence on that. And if it's not extensive, then
Okay.
perhaps a number 4, where subsection 1 would then slide back up, or would stay with number 3, driveway. And then a number 4 would tell you about access
Yeah.
lanes and the number of lots.
I thought that would make it clear. If it doesn't provide too much trouble with trying to link the rest of the code.
Perfect, yes,
yeah.
of course, I'll look at that for and
That'd be
I'll bring
okay
that
with-
to the
Like I said,
findings.
I thought it was accurate, it's just trying to address some of the concerns we hear. Can the average person really read the code and understand it? Is it clear?
That's a good point, thank you.
Item number 12, clarify when general or downtown redevelopment design district specific design variance standards apply for projects in the district. Comments or questions? Oh, Commissioner Pepe, sorry.
Going back to what we were just discussing,
Number 11?
yeah, number 3, to me, I got caught in that a couple of times too, but it seemed like subsection then bullet number 1 and 2, where it calls out specifically the definition of standards for access lanes for widths and access, you need to see this. That to me drove me back to, okay, so there is a difference between the two.
Yeah.
I don't know necessarily if we need to really go further and break that out if the city and staff are not receiving that type of conflict or confusion from.
I mean, I agree, code could always be, I mean, you look at it and you're like, oh, why didn't we originally write it that way? I mean, I think the amendment, again, barring a lot of complications, would be subsection number 3 would be a driveway shall be used to serve a single lot, and then we'd take subsection 1 and attach it to it. And then subsection 4 would be an access lane, blah, 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 and then we'd attach subsection 2 there, see the
Makes a lot of
access lane
sense, yeah.
standards. So I'll look at it and see, and hopefully there wouldn't be any complications, because I think that is a more straightforward way to write the code.
Item number 12, again, any comments or questions, concerns? Commissioner Ward?
I tried to go through this one, and I pulled up the appropriate code section, and this is sort of more of a comment than anything else. At least one of the criteria of subsection 4, lowercase a, lowercase I, through lowercase v of this section, you only have to meet one standard as we go farther down the list to lowercase, actually IV, I'm sorry. If you meet one of these several standards, renewable energy production, enhanced indoor air quality is number 2. Number 3, use of daylight for interior lighting, protection of views of Lakewood Bay or Mount Hood. Number 5, acoustic building performance. Number 6, water efficiency such as rainwater harvesting. Number 7, increased seismic resiliency or alternative design better than blah, blah, blah. It seems to me that anybody designing a building down in that area could easily meet one of these criteria and go for a variance based upon that they're meeting one of these several criteria and
So,
go for it.
just to clarify, we're not changing the actual design variance criteria themselves. We're clarifying which criteria apply when you're asking for a variance for a specific regulation. So the design variance criteria for the downtown redevelopment design district were modified in 2017. Director Siegel was a part of that, so he could answer specific questions about that criteria. But all this is just a maintenance amendment because there was actually several projects where staff thought that both the general and the DRD-specific design variance applied in every single scenario. And this went back to the legislative history, and it was pretty clear that the general apply in certain scenarios and the DRD-specific apply in other scenarios. So that's all this amendment does. It doesn't actually impact the content of the design variance criteria themselves, the general or DRD-specific.
But to Commissioner Ward's question, that's subsection A, those issues, it has to meet one of those in subsection A?
Yes.
Then it has to meet subsection B, has to meet both of
And
those.
subsection B
Right.
has to be met in addition.
Right, so there has to be quality of design, appearance, and materials, and have a unique relationship to nearby structures in addition to one of those other triggers to get a variance in the DRD standard.
So there, as you point out, there are other requirements as well, as that list of, choose one of the 7, and the variance results in the project is exceptional quality and creates a positive, unique relationship. Should be pretty easy to do, I'm thinking, for the,
Not in my experience. They can be pretty rigorous. So the general design variance criteria, it's an either-or scenario for that B that you just read out. It's either exceptional in quality design, or it's a unique relationship. You're creating a unique relationship.
This
And the
is-
DRD,
this
it's
says
actually you have to meet
and.
both. Yeah, so the DRD says both. You have to meet both of those. The
Okay.
general design variance criteria, it's either-or for that one, actually. So it's,
Yeah, and that change was introduced requiring compliance with both exceptional quality detailing, appearance, materials, and unique positive relationships. It was changed to both when that other set or subset of variance criteria came into being, the list that you read off.
choose one of 7.
Because
and-
recognizing that those elements are not always going to be very demanding, and some building designs are naturally going to go toward, some of these, what would typically come up in a LEED commissioned building, indoor air quality or solar voltaic panels on the roof. So we didn't want to just give away, we didn't want to give away the story. We said, you're going to meet these higher level standards on sustainability, and the building is going to be high-quality design from an aesthetic standpoint. And so, anyway, we're getting outside the scope of the code.
Exceptional in the quality of detailing.
yes.
Yeah. But I-
Positive and unique relationship. Okay.
Any further comments, questions, or concerns on 12?
Sorry.
Favor?
Down
Yeah.
there.
Okay.
It's a rabbit hole, it has to be.
Yeah.
I'm so sorry. There we go.
Item number 13, this is the definition for floor area excluded projections. Comments, concerns? None? Okay. Item number 14. Oh, sure. Commissioner Beckett?
Does this get into a question when we come to item 18, where you have projections? Does that include floor area?
So, I'll answer that one. So there is in the floor area definition, there are specific things that are counted towards floor area, and there are specific things that aren't in that definition. I didn't want to clutter this amendment, so I didn't put all of them in there. But things like non-enclosed, like a covered front porch or something like that is not included in floor area because it's not an enclosed living space. And then there's this E, this says allowable projections, and that's a pretty vague term, and this is an amendment that I proposed because there actually is a specific code sections that lists out examples of what projections from buildings could be exempted from the floor area calculations. As far as whether or not projections into the side yard setback plane, it's a good question. You're talking about upper floor projections at that point, typically.
if we-
Like
if-
almost 99% of the time, it's going to be upper floor projection that would automatically be included in floor area. So I don't see that adopting item number 18, which clarifies or restricts or broadens the availability of what sort of projection can go into the setback plane. This doesn't, the two don't impact each other.
Item number 14, the definitions for lot area or lot size and lot coverage, gross acreage. Item number 15, the definitions of caliber and DBH. Done, okay. Number 16, clarify when a pre-application conference for an ADU is required and streamline the ADU definition. Comments or concerns? Number 17, replace the term acreage with lot area, lot size, or square footage as appropriate. Number 18, amend the street front and internal side yard setback planes to clarify the type of projections that may penetrate the planes. So again, I think staff is looking for feedback here on which option does the commission recommend. So comments from commissioners? Commissioner Fisher?
Just a question. You always talked about massing. Can you explain that?
Of course. In response to Commissioner Beckett's question, floor area is another phrase for massing. So when we talk about footprint, we mean like just the outline of the house. When we talk about massing, we're meaning the different floors, so multiple levels if it's a 2-story or 3-story building.
Commissioner Beckett?
Yes, we heard from LUNAC their objections on this one, and they prefer option 3. I would personally say we should not do option 1, but either option 2 or 3 would seem acceptable to me.
Commissioner Hanson or Commissioner Beckett, can you maybe expand upon what your concerns are with option number 1? Commissioner Beckett?
The option number 1, if you look at that and how it's allowed, it would greatly increase the appearance of the house in terms of its size and so on, and part of the concern was massive house against the neighborhood and so on, whereas option 2 and option 3 are less that way.
So the concern is with massing, and then option 1, you feel like has more, as it stated, more potential massing, and option 2 has a little bit less potential massing, but still it increases it. Is that a fair statement?
Yeah, I would
Senior
clarify a
Planner?
little bit in that
Sure.
it just doesn't put design parameters on that massing. It doesn't, it's the actual amount of massing, the width of it at least would stay the same on all 3 options. So how wide the projection was against the overall width of the house. It's more a matter of, is it an entire upper floor section like you see in the house? And these are not, sorry, to clarify, that house on the left, I didn't go through a code analysis to see if it complied with our current code, so just use that as an abstract. But right now, if that was a front yard setback, and both of those kind of upper story projections there, projected into the plane, we would say that that didn't comply because that's wall plane there where those windows are and those projections are. The front setback plane, it would have to be at the roof line or above. And so option number 3 would allow a projections wall plane to project, gosh, this is hard to, so it would allow an upper story wall plane to project into that. Whereas now the massing is brought down in height and it's only kind of It could be a gable end. If that was actually a gable dormer, that would be possible. And that's typical, what we see on front setback planes. You have a gable end facing the street, and the top part of that gable cuts the setback plane, and that's fine. But this image here that shows kind of a full upper story that could possibly project into the front setback plane, that's not currently allowed, and it could be allowed under option number 1. So it's not more massing as far as width, but it could be as far as height, if that makes sense.
Commissioners, any other comments? Commissioner Ward?
My preference would be option 3, essentially no change to the code as it stands.
Commissioner Beckett?
That would be my preference also, with the description on option 2 where it says a little more massing. I think what that gives is a little more modern look to it, and I would be okay with that, but I would definitely prefer option 3.
My concern is that we did take input from the Builders Association, and some of their concerns was that the current code is very restrictive and complex, and I think the nature of this code amendment change is to somewhat make it less complex, look at making it general, but then how far do you go? Option number 1 is, as it states, is the most general, but then you have some massing concerns, which we heard from the neighborhood organizations that they were concerned about massing. So my preference would be to try to make some improvements, make it more general, but be cognizant of the concerns raised by the neighborhood association. So option number 2. Any other comments, or do we want to take a polling? Commissioner Hanson?
I agree, option number 2.
Commissioner Beckett?
I'm okay with 2.
I like option 2. Commissioner Ward?
Option 3,
Commissioner Fisher?
Option 2.
Commissioner Pepe?
2.
Seems like the commission is selecting option number 2, with Commissioner Ward selecting option number 3. So the consensus of the commission is option number 2.
Okay, I'll revise the amendment to just focus on option number 2 then. Thank you for your input.
Item number 9, amend the internal side yard setback planes to exempt steeply downsloped lots. Again, we heard from Lonak and Mr. Bolin on this. Commissioners? Concerns? Commissioner Ward?
I don't think that we should go in this direction. I think we should maintain the side yard setbacks.
So I'm sorry to interrupt in deliberations, but I just wanted to again clarify that a steeply sloped lot is actually a fairly rare occurrence. I just had a counter session with Keith Abel, who's one of our community's very prominent designers, and he had a lot that was 135 feet deep, and there was in the building envelope a 26-foot grade change from the front property line to the most distant portion of a house that he was looking at, and that was not a steeply sloped lot. So he will have to comply, or that house will have to comply with the side yard setback planes. So I don't have a metric of how many lots are actually steeply sloped. It's impossible to say really without having an actual house design, because again, to be steeply sloped, you have to have a 25% grade change between the front property line and the most distant part of the house. So it's impossible to say, outright how many lots are considered steeply sloped, but it's not as common a scenario as you would think, given the amount of sloped lots in the city and hills and ravines. So this is not fully exempting any lot from side yard setback plane. It's just this kind of worst-case scenario where it's very, very difficult to comply with it. So I just wanted to throw that out there.
Planner Hastay, if I understand you correctly, then you're saying, like, the example that you gave, a 26-foot grade change is not considered a steeply sloped lot. It's based on the percentage from the front to the back of the home?
From the front property line. In this particular scenario, because it was a kind of a long, narrow lot, the grade change was not significant enough, even though it was 26 feet between, it was 136-foot elevation. at the front property line and 110 basically at the rear setback, so kind of the outer limits of the building envelope. And no, it was a 22%, I think.
But that's not really what we're talking about here, is it?
No, so
I thought
again,
we're
in
talking
that,
about steeply sloped lots, whereas the example you're describing is not by the definition a steeply sloped lot.
yeah, and that's my point, is that even though this lot had a 26-foot grade change between the front property line
But
and
that's
the
not
back.
really what we're talking about. I thought we were talking about steeply sloped lots.
Right. So again,
And we're asked as to whether we should eliminate the side yard setback standard for construction on what are defined as steeply sloped lots. I don't think we should.
thank you.
Commissioner Fisher?
I was under the impression we discussed this last meeting, and if I can just make a comment, like, I think it was Mr. Bowling, was that his name? Where he said, no consideration was given to, their side or whatever, and it always disturbs me when somebody raises that issue, because my impression is that we were given evidence, we were given rationales for this, and it bothers me that somebody could raise that. And my sense is we've discussed this, and we sort of agreed that this was something that was acceptable. That's why it's here, no?
That's my memory of the commission's previous discussions on this item. That's why I didn't bring it up for further discussion tonight.
Commissioner Pepe?
Please correct me if I'm wrong. We're treating steeply downsloped in the same way that we'll be treating steeply downsloped lots in the same way that we are currently treating steeply upsloped lots.
That is absolutely correct.
I remember that as a key point from our previous
Yeah.
discussion, is that we want to treat the upslope the same as the way as the downslope. It's bringing some consistency to that,
Right.
yes. Okay, so maybe poll the commissioners. Commissioner Hanson in favor, Commissioner Beckett? The question is the recommendation from the commission here to go with staff's recommendation on item number 19, amend the internal side yard setback plane to exempt steeply downsloped lots. So it's to accept item number 19.
Well, I'm
per staff's-
picturing a house that's being built on Lakeview right now. If you drive along there and take a look, it's not a slope, it's a cliff.
I've stopped to look at it.
It literally goes down 16 feet straight down. How would this apply to a situation like that? I talked to the people working on it, and the total height of the house will be about 24 feet, so the top part of it will come above street level, but it's going to take an elevator to get down there. It is pretty remarkable, and I'm wondering how this restriction would apply in a case like that.
Well, there are a number of homes along is it Lakefront or Lakeview, did you say?
It's lakefront.
Lakefront, yeah. So a number of the homes along Lakefront have received RID review or residential infill design variances to exempt them from the side yard setback planes because it has been so impossible to design something that is usable, really, and still complies with that standard. So that might have been one of the homes that you saw that it's received approval of RID design variances. But if this amendment does not move forward, people will continue to have to apply for RID design variances or modify their design to comply. If this amendment moves forward, they would still have to comply with all of their zone dimensional standards and design standards, but they would be exempt specifically from the side yard setback plane.
Okay, I'm okay with
May
it
add,
then.
One of the criteria for the RID design approval is that the design, as viewed from the street, is better in appearance and design quality. And so you think about a severely downslope lot, having to demonstrate that your alternate design is higher, appearance from the street is a little absurd, right? Because it's
Largely
may not even be-
unseen, yeah.
Unseen, so another good reason for the proposal.
I'm good with this. Commissioner Ward?
I am against this change.
Commissioner Fisher?
When we first discussed it, I was against it, but this is what we agreed to. And I think it's a perfect, nothing's perfect, but it's a reasonably accurate statement of what we agreed to, I thought. And so
But you haven't agreed to anything until you vote
Sure.
tonight.
Yes.
all right, well, all right, okay, I'm sorry. It is my understanding that this is what we discussed, and I think this was an accurate reflection of what we discussed. How's that?
Good.
Have I?
Commissioner Pappy?
Good.
Right. Number 20, revise the clear and objective housing standard, the LGVC overlay district, and downtown redevelopment design district standards to ensure consistent language with regards to storefront fenestration. Good?
Yeah.
Concerns?
Good.
Thank you.
Number 21, revise the ministerial development classifications to include specific minor exterior changes necessary to comply with current building or fire codes. Concerns, comments, none? Number 22, revise 2 code sections regulating permit expiration deadlines for consistency and revise how the deadline applies to permits associated with major public facilities. We did receive some neighborhood input from this. I'm just wondering if staff could maybe clarify, what are our options? So specifically with the conditional use permit, the recommendation here was not to have an expiration associated with it. So does the commission have an option to specify? I mean, the neighborhood association made a recommendation of maybe we consider 3 or 5 years to be consistent with the other term expirations. So what is the commission's options?
I mean, yes, you could propose additional language. I would point out that a conditional use permit approval is based on a specific intensity of that use. Say for a high school, it's based on the number of students that would be allowed on the site. There would be a CUP comes with a cap, if you will. You can't go past that in enrollment. So any sort of intensity or intensification or increase of use on a site would automatically trigger a modification of that original conditional use permit. So it's not that once a conditional use is approved, anything goes on that site. That's not the way that this code works. It's just that if the intensity stays the same, you don't have to come, every time you come in for, say, an exterior update on siding, which is we're seeing happen a lot with this school bond, you don't have to go back through the conditional use analysis, which nothing has changed, so the analysis is kind of a moot point anyway. The only thing that we're proposing to change in this code is extending the amount of time it would take for a DR permit to expire. Currently, the code does not require the conditional use to be subject to an expiration deadline. But if the commission wished to, I suppose you could tonight impose a deadline on the CUP permit, but that would be changing how our current code is enacted.
I think you addressed, at least for me, some of the concerns that were raised by the neighborhood association. I think the concern I heard was that, conditions change, and then the concern was that the conditional use permit wouldn't account for those changing conditions. But I think what you've addressed is when the conditions do change, then that automatically triggers a new conditional use permit. So
That's correct.
Okay. Commissioner Beckett?
Again, just to clarify, this
I'd
is,
written down,
Sorry, Commissioner Beckett was first. Commissioner Beckett.
I had written down a question here. What of an abandoned project? I'm not even sure what that would consist of. Construction that started and then somebody walked away from it?
Are you referring to the
This is the,
conditional use permit, the standard that would be left there in LOC 50.07?
you had
055?
abandonment of conditional use permit,
Yeah.
so they've walked away from the conditional use permit. What if they've walked away from the project already? I don't know why people do that, bankruptcy or something, I don't know.
I know that the abandonment of a conditional use permit, I can give you a specific example of, I think this was a conditional use permit. That's actually not. Mr. Boone, can you think of a specific example?
Well, I think we had issues come up with churches.
Oh.
So you have a church operating on there, it ceases operation, it goes to a bigger facility or whatever, you've got this building that was approved to conditional use as a church. So a year, 2, 3 years goes by, and then the question is, can you resume its use as a church after that period of time has passed, or must it get a new conditional use permit? I mean, you're sort of balancing the question of the neighborhood, saw it go away and sort of adjusted to that, and then the property owner wants to, after it's terminated that use there, it wants to revive that use, if you will. Should it come in for a new conditional use permit? That's the question.
So again, we're not changing or proposing any changes to that specific language for abandonment. It's just, we're trying to consolidate the code language. And so that abandonment language stays where it is as existing. It's the, whether or not a major public facility that was subject to a conditional use permit, whether or not the DR portion of that approval would expire or not.
Commissioner Pepe?
Again, correct me if I'm wrong, please, but this just pertains to municipal,
Major public facilities.
right? Not major private construction.
Right. I mean, the question was asked about abandonment, and that's what's left in 5B, 500705
Right.
5B. What is stricken from that section is the provision that says a 3-year limitation that requires construction within 3 years for a major public facility has, normally, you have 3 years to start your project, okay? But the 3-year limitation does not apply to permits issued for major public facilities. That's in the current code, okay?
Right.
So that would be stricken, and it would be driven by 50070317, which talks about expiration of development permits, and that gets into the, I think, the conditional use for major public facilities would still
Would be
would
exempt.
apply to both public and private. But on the DR side of things, the question is, there would be a slightly different timeline for the DR of private versus public facilities, major public facilities.
Can you go back and
So-
clarify what you said regarding that it would still be the same for public and private facilities?
For the conditional use. Right. I mean, there's
So this would strike it for a private, construction of a private facility as well?
No.
They would not.
Absolutely not. No, this is.
Right.
Okay, so if you look at actually page 34 of attachment 2, I've added one sentence there. And the first part of that sentence, where it says for major public facilities, the 3-year limitation does not apply to conditional use permit, that is existing code. Right now, conditional use permits for major public facilities do not expire. You would have to come back for a modification if you increase the intensity of the use, or a new CUP if you abandoned that use altogether for that timeline that's talked about down there. But that first part of the sentence is current code, it's just been relocated. The second part of the sentence applies to the development review permit that comes with a conditional use, like a new high school on there. If you did not build the high school and all of the improvements within that 5-year deadline, then the DR permit would expire, and that's the new language. Right now, they're subject to a 3-year expiration deadline, and you discussed extending that from 3 years to 4 or 5, and I came back with 5 at the recommendation of department heads that do manage these sorts of projects.
And so after 5, if nothing happens, then the
If you
project
haven't
is in the.
completed the 15% construction,
it's
blah, blah,
dead.
blah, yeah. You would have to, it's dead as far as that specific use or that specific approval. You could come back around, but you would
Sure.
have to do the whole DR permit again. The CUP, again, as long as nothing changed about the intensity of the use, would still be in effect. So the example I used at the previous work session was the
Right.
Lake Ridge High School grandstand stadium cover. The CUP that analyzed the impacts from that as far as, is there any increase in parking? Is there any negative impact on the neighborhood with extra noise or extra people attending games? That was done in 2014 and didn't expire. But the DR portion of that from 2014 did, because they never constructed it. 5 years later, they had to come back and reevaluate the design, and they made some changes to it. But that's, I think in keeping with what the commission was talking about, in that you want to keep the projects moving forward in a timely manner, understanding that major public facilities might be subject to some delays that private projects may not, like public funding, things like that. And so
Right.
you propose.
That's just, I just have, where my conflict is, is when you don't hold the same parties, or parties that are working towards the same goal, to the same standard.
No.
So that's, I got a bit confused when you were saying that they are treated equally, but it doesn't sound like that is the
For the
case.
abandonment side, yes.
Right, I'm not worried about the abandonment.
Yeah.
And I think the staff's, well, let me see what the staff thought. Public projects receive more press, okay, and more public awareness than private projects. And I think that was the theory of a different timeframe.
Again,
That could be an arguable
Well,
position.
That's why
But,
it's
yeah, I-
brought to you.
That's why it was a policy amendment, not a maintenance one. And again, in my experience, my more recent experience was several school projects with the city hall next door. The amount of public engagement that was above and beyond what was required by code that was undertaken for those projects.
Yeah.
I mean, that was distinctly, it's not that private developers don't occasionally go above and beyond, but it's also not typical either. And so, but I think that these major public facilities, because they do use public funding, because they are usually very large community projects, and they are driven by, say, the school district or the city, one of the departments in the city, there's a lot more upfront engagement, a lot of like outreach to the community. And so I think that does differentiate them, not 100% of the time, but that does differentiate them from private projects.
And the public contracting and procurement processes are, you know, the timelines are way out there compared to what private sector is managing.
And the original proposal from staff was to just exempt it completely for both the CUP and the DR.
Right.
And the commission did not approve of that suggestion. And so it was maybe a little bit more flexibility, but not, you know, complete flexibility or complete exemption.
Commissioners, are we good on item number 22?
Sure.
Commissioner Pape, you're not? You're okay on item number 22? I thought you were saying you were kind of objecting to
Yeah,
recommending
I
approval.
still don't agree with it.
Okay,
but-
okay. All right. Item number 23, improve parking area efficiency for commercial uses, revise the parking standard to allow commercial tandem or valet parking spaces to meet the minimum parking requirements for certain uses under certain circumstances. Okay with this? Commissioners, comments, concerns? Commissioner Ward?
My only concern, I just want to reread this. Yeah, I'm good with it as is. It just, as long as it says vehicles do not require backing into public right-of-way.
Okay. Deputy Attorney Boone, is the procedure now, should we make a motion, a preliminary
could I
motion to
add
find, more discussion? Commissioner Ward, sorry.
I would like to add to that. There's a situation could arise where they would be driving in forward into the public right-of-way. So I
Yeah,
would
that would happen now.
like it to say that the public right-of-way shall not be used as part of the valet parking planning or valet parking use.
I'm not sure that would, I mean, I think a certain amount of the public right-of-way has to be used in order to maneuver vehicles, and I think that might introduce
You're right. So it's backing that we want, that
Yeah,
I'm thinking about, because it's a little more dangerous than
Exactly.
driving in a forward motion.
Exactly,
Yeah,
yeah.
I'm sorry.
Commissioners, we did add the language in there, the provision where the city engineer may approve backing onto a public alley, because that's where you would often find those turning movements and maneuvering of vehicles.
Okay.
As to procedure.
Yes.
Ultimately, the commission would be recommending, well, the commission is recommending to the city council. The commission could recommend, and that's the, when I say the commission, that would be a majority of the commission. If a majority of the commission approves all of the recommended amendments, that would be one motion, one vote, done. If the commission wants to peel out and vote on separate recommendations because the commission decides, well, we love all of them, but 17 and 22, you could certainly peel those out and then vote on those separately and make a recommendation to the council on those separately. So,
Thank you, Deputy Attorney Boone. I think what we heard tonight from the commission is, in most parts, the majority of the commission is okay with the amendments. There's a few amendments or policy items that maybe individual commissioners maybe have issues with, but overall, it seems like the commission would be in favor. So would anybody like to make a motion or comment, Commissioner Fisher?
I think, from my understanding, is we all agree on almost everything except the one where we have to select an option.
Oh, yes,
So-
correct.
So it seems to me that one should be a separate vote to which option we're going to take, and then do we approve of it?
But I think we kind of took that polling. We could do that, but I think we already have those numbers
Okay,
that the majority accepted.
is that,
Yeah, I think,
On option number
I think
two.
each of them have been pulled where there has been dissension, and majority,
Do we need to make a specific motion on that amendment for the option?
the polling would be captured in the minutes that would go to the city council or the staff report that would go to them.
The findings
But
then would be
the-
based on option
The
number two.
findings would be the whole, would find that all of the amendments meet the criteria. And
Okay.
you'd recommend adoption of all the amendments then.
But on that specific item where there's three options, would it be a note that the commission recommends option, the majority of the commission recommends option number two?
Could that be built into the motion? Mr. Boone?
Well, I mean, I guess it's sort of a footnote kind of a thing, because again, it's the commission making a recommendation to the city council. It's, if you want to footnote that one commissioner voted,
No, I think it was just the consensus, and that was
Yeah.
the question, is if the motion would include, would specify that under item number 18, option number, whatever the option
Yeah,
is.
option number two is what the
two
commission said,
is
yes.
the motion.
Why
we can
don't
do
we
that.
do this?
If that's
Let's
what
vote on option 18, or number 18, option 2, to pass that specific option, and then vote on the rest of them as a block.
Thanks, Commissioner Beckett. You can take that into consideration. Commissioner Pape?
I think we've already kind of taken care of option, not this one, 18.
Yeah, on number two.
Option 1, 2, or 3, and it
We picked
came
that.
down to option 2. So my understanding is if we put this all together or we separate this one out, it would more than likely go forward with 18 and option 2. And I thought
Yeah, I
that's
think-
what you had mentioned.
That's
After we
the-
kind of took that straw poll, you were going to go back,
I think
move forward with option 2.
I think we can make that type of a motion, make a specific motion to approve the code amendments on item number 18 to specifically recommend option number 2 to the city council.
That's what
That'd be
my
part of the
understanding
specific motion. And the other one, I think the other action we took was for staff to go back and look at, on the flag lots, is there possible further clarifications? Just, I think it was reorganizing the text into sections.
Right, sorry. So that was also item number 11.
Picture of Bill's drawing and call it good.
Yeah, I think it's item number 11, yeah.
Yeah.
Commissioner Ward?
As far as item 18 goes, looks to me like I was outvoted, so that the commission would be recommending option 2. And I think it could just be pretty clean
Yes, I agree.
and not get involved with, a discussion about one dissenting commissioner.
Yes, exactly. I think that's the direction the commission would like to go. Yes. Was there a motion?
I move that we approve item 18, option 2, plus all the rest of the items.
Or a discussion on the motion? Maybe discussion, Commissioner Ward?
No, I was going to second the motion to pass ordinance 2832.
Just for, you're recommending to the city council that it adopt that ordinance. Right.
Maybe we can further clarify the motion, then. It's to recommend that we approve LU 19-0033, and specifically on option 18, that we recommend option number 2.
Yes.
Item number 18. Second,
Second.
all those in favor?
Aye.
Aye.
Any opposed? Any abstain? None?
All right, those are tentative decision and written findings we brought back to the commission for the next meeting, which would be the
The 25th.
25th.
Okay, so now that the motion has been passed, I just want to clarify that I will look at item number 11 to see if we can divide it into driveways and access lanes. And number 18, I will get rid of options 1 and 3 and finalize it to option 2. Thank you very much.
Yeah, thank you. And for purposes of the minutes, we would typically try to capture that straw polling that you did. So just so you're aware of that.
Okay, thank you. So next on the agenda, Commissioner Beckett, question?
Well, I'd just like to thank Ms. Hastay. Ms. Hastay, I would like to thank you because I was up scouting out that tower up on Cooks Butte, and I had you on the phone about 5 times figuring out what to do. So thank you. It's now irrelevant, but we
Well,
got
it may
there.
come back in a different location, so I think time not badly spent, but thank you.
Right. Next on the agenda is other business. Tonight, we did have 8.1 nominations and elections of chair or vice chair. So I think in the discussions that I've had with commissioners, I've expressed interest to be chair, and Commissioner Pape has expressed interest to be vice chair. Do we have other nominations that people would like to bring forward? Or Director Siegel, did you receive any nominations? I thought we may have mentioned that you could send them to us or to staff. But
Don't think we have any, although it doesn't preclude anyone from nominating.
yes, you can nominate
themselves or
currently.
others.
We'd like to take a vote? Or is there should we do it through a motion to approve myself as chair and Commissioner Pape as vice chair?
Yes, I nominate Chair Heap to be chair and Commissioner Pape to be vice chair.
Commissioner Hanson, you're then raising the motion to approve myself as chair and
I am.
okay, and there's a second?
Second.
I'd second that.
All in favor?
Aye.
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 Any abstains or nays? None? All right, thanks. Next is a schedule review.
Okay, so your meeting on the 25th of November, you'll be reviewing findings for the public hearing and tentative decision that you made this evening on the annual CDC amendments. You also have the third and what we expect will be the final work session on goal setting for 2020. The public comment period on the commission's tentative list of goals ends on the 15th, so Friday is the last day to submit written comments to through that process, although I understand the commission will be receiving public input on the 25th when you're reviewing your draft goals. There is a Boards and Commission Summit scheduled for December 5th and a joint study session with the City Council on the 17th of December. And I believe the preliminary quorum check we did, we found that I think 5 of the 6 of you are available for that evening, so that's a go. And then your final Planning Commission meeting of the year, December 9th, we have still a tentative item, but we're hoping to have our telecommunications staff with the Public Works Department who have been working on telecommunications regulations in the right-of-way to come speak with you about that process and We're still doing our due diligence to see what, if any, changes might be required on the community development code side of things for small cell. So we haven't really scoped that out yet, but that's really the purpose of the work session on the 9th, is to begin kind of the discovery process on that. Also on the 9th is a work session on possible amendments to the R6 zone in the First Edition neighborhood. And that concludes the schedule update for the year. We have projected out some of the projects into 2020 that we know of at this point, so you can, take a look at the schedule there. We'll be adding to that as we get closer to the end of the year. So happy to answer any questions.
Commissioners, any questions on schedule? Commissioner Beckett, did you have a question on schedule, or you're?
Not on the schedule, just a different comment.
All right, so it looks like, yeah, we're good on the schedule. Commissioner Beckett will allow you to make a comment.
Yes, I emailed this to the other commissioners, but I should just point out in general that the Wall Street Journal today had a prominent article with a picture of the lake at Lake Oswego and the headline that Oregon's town proposed tax undercuts state housing plan. So in other words, they're suggesting that if the council goes ahead and imposes a $15,000 fine on the demolition of a house, that it will somehow undo HB 2001. I'm not saying I agree with that, but that's the argument that's put forward in the Wall Street Journal.
Thank you for the comment, Commissioner Beckett. So seeing no further business, I'll adjourn the meeting. Meeting adjourned. Thanks.